courtrooms are built on the assumption that law holds, that the walls of a courthouse, the weight of a robe, the oath sworn on a Bible, all of it adds up to something that keeps violence at bay. Most of the time, that assumption holds, but not always. There are moments, rare and brutal, when the courtroom stops being a place of order and becomes something else entirely. When a defendant decides the proceedings are over. When desperation or rage or pure calculation overrides everything the room is supposed to represent. And when that happens, people die. Sometimes it's the innocent who don't walk out. A judge, a lawyer, a juror who showed up to do their civic duty. And sometimes it's the defendant himself who doesn't survive the chaos he started. These aren't stories about wrongful deaths or disputed force. They're about what happens when the line between verdict and violence disappears in a matter of seconds. About how quickly a room full of people following procedure can become a room full of people trying to survive. Here are 5 convicts instantly killed in court. It was the spring of 2014, inside a federal courthouse in Salt Lake City, Utah. The trial had been running for several days. Asiel Angelou, a 25-year-old member of the Tongan Crip gang, sat beside his defense attorney at the counsel table. He was one of 17 people named in a 2010 federal indictment charging gang members with assault, robbery, conspiracy, and weapons offenses. He was the last defendant in the case to face trial. The others had already been sentenced, most to terms between 10 and 30 years. Before the proceedings began, Angelou had made a specific request. He asked the judge to let him remain unshackled during trial. Former U.S. Attorney Brett Tolman later explained the reasoning behind that kind of arrangement. When a defendant appears before a jury in restraints, it creates an impression. The concern is always that shackles will prejudice the jury before a single witness takes the stand. Angelou told the judge he would behave. The judge agreed. The witness on the stand that morning was a current or former gang member, testifying about how he had come to that life. He was shackled. He was speaking about the path that led him into the gang when something in the testimony shifted the atmosphere at the defense table. Angelou stood up. He reached over and grabbed his attorney's pen. Someone in the courtroom yelled, "Whoa, whoa, whoa!" But the warning came too late for anyone to physically intervene. He moved fast, crossing the distance to the witness stand in seconds, then leaped, right arm raised, pen in hand, aiming at the shackled man on the stand. The witness lurched backward just far enough that the blow didn't connect cleanly. Angelou came down feet first over the front of the stand. A U.S. Marshal, identified in court records only as Jane Doe, fired 4 shots at close range. Angelou was hit in the chest. He went down. Officers rushed forward. Someone ordered him to drop the pen. Someone else called 911. U.S. District Judge Tana Campbell was escorted from the room. The defense attorney had gone under a desk. Prosecutors stood frozen where they were. Angelou was still breathing when paramedics moved him out of the courtroom. He died at a local hospital that afternoon. A mistrial was declared. The Justice Department sought to keep the courtroom footage sealed, citing concerns about retaliatory gang violence. A media coalition that included the Associated Press and a CBS affiliate in Salt Lake City fought for years to have the recording released as a matter of public record. It finally became public in 2018. The footage is 24 seconds long and shows everything. The marshal who fired was cleared of any wrongdoing by the FBI almost immediately. A federal review board found the use of force consistent with agency policy. Angelou's family filed a wrongful death lawsuit, arguing the pen posed no lethal threat and that 4 shots were excessive, particularly since 3 of them came after he had already fallen. U.S. District Judge John Dowdle dismissed the suit. In his ruling, he wrote that after reviewing the video, he had little difficulty determining the marshal's use of force was objectively reasonable, given the totality of the circumstances. The spokeswoman for the marshal's service offered a shorter version of the same conclusion. The video, she said, demonstrates how quickly violence can erupt in any situation. Person County Courthouse in Roxborough, North Carolina, sits in a small county seat about an hour north of Durham. It handles the ordinary business of a rural court, traffic violations, property disputes, criminal matters that rarely travel beyond the county line. Christopher Thomas Vaughn was 36 years old. He was on trial for false imprisonment, a charge that, in the vocabulary of criminal law, means exactly what it sounds like: holding someone against their will. The details of the underlying case weren't elaborate. What followed the verdict was, when the jury returned a guilty finding, Vaughn didn't absorb it quietly. He became enraged. He charged toward the judge's bench. 2 sheriff's deputies moved to intercept him, and a struggle broke out in front of the courtroom. During the scuffle, Vaughn tried to take a bailiff's weapon. A police officer fired. Vaughn was shot inside the courtroom. He didn't die immediately. He was transported from the courthouse and received medical attention, but he didn't survive. Authorities confirmed his death, and the North Carolina State Bureau of Investigation took over the inquiry into the shooting. The SBI's initial news release described the sequence without ambiguity. Vaughn had been found guilty. He charged the bench. Deputies intercepted him. He went for a weapon. An officer fired. The investigation would determine whether the use of force was justified, but the facts on record left little room for confusion about what had set everything in motion. What the record shows is a man who heard a verdict and concluded, in the seconds that followed, that the legal process was no longer something he would participate in. He had been convicted of holding someone against their will. The irony of what came next was direct and without subtlety. He responded to that conviction by charging a judge's bench and grabbing for a gun. Person County is the kind of place where a courthouse shooting doesn't happen. The building isn't designed against that kind of event. The deputies who moved toward Vaughn were doing what deputies in small county courthouses do every day: standing between the accused and the bench, managing proximity and tension without incident. On this day, that routine failed to hold. The SBI investigation ran its course. No charges were filed against the officer who fired. The shooting was ruled a justified use of force in response to an attempt to seize a law enforcement weapon inside an active courtroom. One detail stands out in the broader shape of this case. The charge Vaughn faced, false imprisonment, is not a violent felony in the way armed robbery or assault is understood to be. It doesn't carry the kind of sentence that might drive someone to desperate calculation. There's no indication from the available record that Vaughn faced decades behind bars, or that he had any strategic reason to believe violence would improve his situation. What the record suggests is simpler and harder to explain. A man who could not tolerate the word guilty and moved before that word had finished settling in the room. Vaughn had walked into that building as a defendant. He left on a stretcher. The jury that found him guilty of false imprisonment had completed its function before he ever got close to the judge's bench. What he did in the seconds after the verdict was read made their decision almost incidental to what the day became. The jury deliberated. They returned a verdict. And then the courtroom stopped being a courtroom. The Carroll County Courthouse in Hillsville, Virginia, sits at the edge of the Blue Ridge Mountains in the southwestern corner of the state. In March of 1912, it became the setting for what newspapers across the country would call the Hillsville Massacre, one of the deadliest courtroom shootings in American history. Floyd Allen was 55 years old and a known figure in Carroll County. He had served as a deputy sheriff. He came from a large, tightly bound mountain family with deep roots in the region and a documented history of conflict with local law enforcement. The charge against him was interfering with an officer of the law, specifically freeing his nephews who had been arrested after a fight. Allen and his family believed the case against him was political. The county had recently seated Republican officials, and the Allens, who backed the Democrats, felt they were being singled out. On the morning of March 14, 1912, Allen stood in the courtroom to hear what the jury had decided. The room was full. Members of the Allen family had come armed. Court officials, including the county clerk, were also carrying concealed weapons. Sheriff Lewis F. Webb, who had taken office just 2 months earlier, had borrowed a pistol from a cousin that morning on his way to court. Both sides had prepared for something, though perhaps not exactly what came. The jury found Allen guilty. Judge Thornton Massey imposed the sentence, 1 year in the state penitentiary. Allen stood. He looked at the court and said, "Gentlemen, I ain't a-goin'." What followed took less than a minute. Shots rang out. Who fired first was never definitively established. and courts and historians have debated the question for more than a century without resolution. By the time it was over, 5 people were dead or dying. Judge Massey was shot and killed. Sheriff Webb was killed. Commonwealth's attorney William M. Foster was killed. A juror named C.C. Fowler was killed. A witness named Betty Ayers was shot in the back and died the following morning. 7 others were wounded, Allen among them. The Allen family scattered. Some ran into the surrounding mountains. Allen himself, wounded, made it to the Hillsville Hotel. The governor called for a manhunt. Pinkerton detectives were brought in. It took 6 months to bring everyone in, with 2 participants eventually caught as far away as Des Moines, Iowa. Allen was tried for first-degree murder. He pleaded self-defense. The jury convicted him quickly. He was sentenced to death by electric chair. His son Claude received the same sentence in July of that year for his own role in the shooting. 4 other family members received prison terms. Governor William Hodges Mann refused to commute either death sentence despite widespread public appeals. He granted 4 reprieves, reportedly waiting to see whether the Allens would confess to having conspired in advance. They did not confess. On March 28, 1913, Floyd Allen and his son Claude were executed at the Virginia State Penitentiary. The estates of both Floyd and J. Sidney Allen were seized in settlement of wrongful death suits brought by the families of the judge, the prosecutor, and the sheriff. The law at the time allowed nearly everything to be taken. In J. Sidney Allen's case, even the raw bacon in his pantry was inventoried and sold before it spoiled. Years later, Governors E. Lee Trinkle and Harry F. Byrd Sr. commuted the sentences of the Allen family members still in prison. The Carroll County Courthouse still stands. The courtroom today is 20 feet longer than it was in 1912. The Carroll County Historical Society keeps a diorama of the original room on display, along with photographs and newspaper accounts from the day everything inside it came apart. On the morning of April 2, 1985, Ronnie Lee Gardner was transported from the maximum security unit of the Utah State Prison to the Metropolitan Hall of Justice in Salt Lake City. He was 24 years old. He was appearing for a pretrial hearing on a second-degree murder charge, the killing of a bartender named Melvin John Otterstrom during a robbery at a Salt Lake City tavern the previous October. As Gardner and his guards entered the basement lobby of the courthouse, a woman named Karma Jolly Hainsworth approached and handed him a gun. She had also hidden a bag of men's clothing, duct tape, and a knife under a sink in a women's restroom in the basement, placed there in advance for his escape. Gardner fumbled with the unfamiliar weapon. His guards retreated toward the parking lot. Gunfire was exchanged. Gardner was shot through the lung. Wounded and still moving, he pushed into the courthouse archives room where a court clerk, a prison officer, and 3 attorneys had taken shelter. 2 of the attorneys, Robert Macri and Michael Burdell, had pressed themselves behind the open door. Gardner pointed the gun at Macri. Then he shifted his aim. Burdell said, "Oh my God." Gardner shot him in the head. Burdell died in surgery approximately 45 minutes later. He had $5.97 in his checking account the day he was killed. He had been doing pro bono legal work for his church. Gardner then forced a prison officer to lead him out of the archives room toward a stairwell. Crossing the lobby, he ran into Nick Kirk, a 58-year-old uniformed bailiff who was unarmed and had just stepped off an elevator. Gardner shot him in the abdomen. Kirk survived, but the bullet tore through his stomach, intestines, and hip, and he spent the remaining years of his life in chronic pain. He died of a heart attack in 1995. His family said the shooting had effectively ended his life a decade before it finished him. Gardner made it outside, briefly took a vending machine serviceman as a hostage, then surrendered to police in the parking lot when he found himself surrounded and out of options. He was convicted of capital murder in October of 1985 and sentenced to death. What followed was nearly 25 years of appeals moving through state courts, federal habeas petitions, and reviews by both the Utah Supreme Court and the 10th Circuit Court of Appeals. 3 of the jurors who had sentenced him later signed affidavits saying they would have recommended life without parole, though that option hadn't existed in Utah at the time they voted. Gardner told the parole board he had changed, that he understood the damage he had caused, that he wanted to spend whatever time remained counseling young inmates. The Board of Pardons and Parole voted unanimously against commutation. The U.S. Supreme Court declined to intervene. On June 18, 2010, just after midnight, Gardner was executed by firing squad at the Utah State Prison in Draper. He was strapped to a black metal chair with a white target pinned over his heart and a hood over his head. 5 anonymous volunteers, all certified police officers, fired .30 caliber Winchester rifles from 25 feet away. One rifle held a blank. Gardner's arm tensed when the round struck. The medical examiner stepped forward, checked for a pulse, and removed the hood. Gardner was pronounced dead at 12:17 in the morning. Asked if he had any final words, he said simply, "I do not know." It was the first execution by firing squad in the United States in 14 years. It was the morning of June 17, 2019, in downtown Dallas, Texas. The Earl Cabell Federal Building and Courthouse occupied a full block on Commerce Street. It's concrete face routine to anyone who worked downtown. By a few minutes past 8 in the morning, the heat was already climbing, and the sidewalks around the building carried the ordinary traffic of attorneys, jurors, and staff heading inside to begin the day. Brian Isaac Clyde was 22 years old, a U.S. Army veteran who had spent 4 years in the service before being discharged. People who knew him from his recent classes at a community college had said he was quiet. He had also been posting steadily on social media in the days and months leading up to that morning, content that grew darker over time and ended with material consistent with the framing of a planned attack. He walked toward the courthouse wearing a tactical vest and carrying an AR-style semi-automatic rifle, along with multiple loaded magazines. As he approached, he opened fire toward the building's plaza entrance. The Federal Protective Service officers stationed at the courthouse responded within seconds. They moved toward the gunfire rather than away from it, returned fire from cover, and brought Clyde down on the plaza before he could enter the building. He was struck multiple times. Emergency medical teams reached him quickly. He was pronounced dead at the scene. No one else was killed. A passing driver and a journalist nearby were struck by debris and minor fragments, but survived. Inside the courthouse, employees took shelter under desks and behind doorways as the building went into lockdown. The plaza where Clyde fell was held as a crime scene for the rest of the day, while federal agents worked through what had happened. What the FBI assembled in the hours and days afterward was a record consistent with a planned single-shooter attack on a federal courthouse. Clyde had not been a defendant. He had not been a witness, a juror, or a staff member. The reason he chose that building on that morning was not fully clarified by the available evidence. What was clear was that he had prepared for the act and intended to enter the courthouse with the rifle. Federal officials later described the response as the kind of outcome the training is designed for. Officers stationed at federal courthouses run drills for exactly this scenario: the armed approach to a public entrance during business hours. In most plans, the worst case is that the attacker reaches the lobby. Clyde never did. What this case adds to the count is not the same shape as the others. He was not a convict at sentencing or a defendant absorbing a verdict. He was a man who chose a courthouse as the place where his story would end, walked toward it with the means to take other lives, and was stopped at the door by people whose entire purpose was to make sure he did not get inside. The courthouse opened for business the next day. Cleaning crews worked through the night. By morning, the plaza looked the way it always did. The doors operated normally. The building absorbed what had happened and continued. The man who had walked toward it the morning before never made it past the entrance. What this case shares with the others in this video is the speed of it. The shooting on the plaza lasted seconds. From the first shot Clyde fired to the moment he was on the ground, the entire exchange ran shorter than the time it takes to read this sentence aloud. The Federal Protective Service officers had no opportunity to negotiate, no chance to attempt de-escalation, no version of the encounter where Clyde could be talked down before lethal force became the response. He had arrived at the plaza already committed to the act. He had announced that intent with the first rounds he fired into the building's facade. The decision in front of the officers was not whether to use force. It was how quickly they could apply it. In the weeks that followed, federal officials reviewed the response and found it consistent with training. The officers involved were not named publicly. The Protective Service does not generally identify the agents who fire in incidents like these, and the standard reasons were cited in this case: their personal safety, the operational integrity of the unit, the ongoing risk of copycat threats. What Federal Protective Service leadership did say openly was that the men and women stationed at courthouse entrances exist precisely to put themselves between a threat and the people inside. On a Monday morning in Dallas in 2019, that is what they did. What these 5 cases share isn't geography or era or method. They stretch across more than a century, from a Mountain County courthouse in 1912 to a federal courtroom in Salt Lake City in 2014. The men involved came from different circumstances and acted for different reasons. Some had spent years accumulating violence. Others snapped in a single moment after a verdict they couldn't absorb. What connects them is one thing. Each of them, at a specific second in a specific room, decided that the proceedings were finished on their terms rather than the court's. In every case, the court disagreed. In every case, the consequences were immediate and irreversible. Courts run on the shared understanding that everyone inside them has agreed, however reluctantly, to let the process conclude. These 5 cases are what happens when that agreement collapses. The room doesn't stop being a courtroom. It just stops feeling like one.